You're watching FJTN, the Federal Judicial Television Network. Coming up on Court to Court.
We can forecast alternative futures even though we cannot predict the future.
You can't just appoint people to go do this. You have to do it yourself.
The game plan of it is to show that the court is open to suggestions and we want our constituent input.
This is Court to Court, your connection to what's happening in the federal courts around the country, providing information and ideas that will enhance your job and how the courts function. Now with today's program, Michael Burney.
Welcome to this edition of Court to Court, the educational magazine program for all court staff from the Federal Judicial Center. Today we'll be challenged to create the future rather than react to it. We'll see how two courts are meeting that challenge, and we'll find out that there's more to Java than just coffee. On today's program, we'll hear a lot about strategic planning. That phrase doesn't mean planning for what we think will happen, but rather strategic planning is about making things happen. It's about creating the future. Historically, planning for the future may have meant how much office space or how many desks we'd need if we hired new employees. But today, management consultants such as Jim Dater challenge organizations to think further into the future and also to think differently about the future.
Jim Dater is director of the Futures Studies program at the University of Hawaii. He addressed one of the center's federal court leadership programs.
So futures research is intended to relate to planning as planning relates to administration. Well, the thing that makes it hard for individuals to think about the future is that we are still animals who are conditioned to stimulus and response. We learn by what we do and by the things around us. And by nature, looking ahead into the future is not something we've yet experienced. So it's very difficult for us.
At the workshop, Dater made clear what futures studies are, that they are about influencing and creating rather than guessing.
That the future cannot be predicted because the future does not exist. One of the problems of the English language is the assumption that there is something called the future out there, that it pre-exists and it can be predicted, but the future does not exist, and therefore it cannot be predicted. We can forecast alternative futures even though we cannot predict the future. So forecast is different from prediction. Your image of the future is one of the most important components in creating the future. Your image of the future that then encourages you to act or not act in certain ways is tremendously important.
The point was not lost on the participants.
Oftentimes we're so busy doing our jobs that we don't take the time to think about how we would react to future circumstances.
You never want to be in a position to be reactive to change, but rather want to consider it.
We need to look at the emerging trends that each court is faced with. Those emerging trends could be either economic, they could be technical, or they can be social.
Dater's message for organizations is to take the lead in creating what their future will be.
Even though the future cannot be predicted, alternative futures can be forecast and preferred futures should be envisioned and created. And so the basic work of future studies is the development and forecast of alternative futures and helping organizations envision and then create their preferred futures.
Envisioning a future for a court means paying attention to a multitude of trends and how they affect delivery of services. The Federal Judicial Center was created to help the courts plan strategically and to increase productivity and quality. One technique is called total quality service, or sometimes total quality management. It's a program that can work regardless of a court's culture.
The Court of Appeals for the 10th Circuit in Denver began implementing a total quality program about 4 years ago. An early task in the process was asking court users for feedback about court services. Janine Jensen, a U.S. public defender, often needs copies of court documents. and something as simple as access to the copy machine was a problem.
And it would be so stupid because you might need 2 pages of a document and you'd stand there and only one person would have the key to the copy machine. By the time you wait for the right person to show up and then to be free from the telephone so that they can come out and turn on the copier and stuff. It was always just these annoyances that don't sound very big, but they really grate on you.
Seemingly small concerns are a big part of strategic planning, says management consultant Dale Lefevre.
So the issue of strategic planning is not about challenging the core functions of what the court does. It's really challenging the way they deliver on the services, either the quality of it or the procedures.
Total quality service is not just business management school flavor of the month, says Patrick Fisher, clerk of the Court of Appeals for the 10th Circuit. At a court managers conference earlier this year, he talked about those initial feedback sessions.
We interviewed each other. We interviewed circuit executives, staff attorneys, judges, secretaries separately. We did attorneys. We did the AUSAs and the federal public defenders. We tried to talk to everybody who we could identify as a customer. There are only 4 questions. What do you want? What do you mean? How are we doing? And how important is it?
In those interview sessions, we said, everything counts. You can say anything without regard to budget or concern about other people hearing it or available resources. Tell us, in a perfect world, what we can do for you.
I think most people's first reaction is, I wouldn't be caught dead at a meeting like that. Either because they don't feel safe doing that, or because they think it's a big waste of time.
But Jensen was surprised by what happened at the meeting.
And it was really unexpectedly fun because it turned out to be more of a dialogue where I would say, you know, this would be really helpful if you could change this. And they'd say, well, gee, we could. And we could do that next week.
And we had flip charts and we wrote all this stuff down and we've analyzed it and come up with some things that we have changed and things that we emphasize. Timeliness. Timeliness of docketing is important to our external customers. We didn't know that they cared.
The problem with most organizations is by the time they work on a trend, it's already become an issue. And what I mean by an issue is somebody is requiring from the outside that you do something about it, which means you've really lost your freedom and your control over it. The earlier you catch a trend in this development, the easier it is to respond to it.
Chief Deputy Clerk Betsy Shoemaker said the 10th Circuit's Court of Appeals initiated a total quality program because they knew smaller budgets would be part of the long-range future, and they could streamline the court's operation by giving customers what they want.
So that we were doing what they needed us to do rather than perhaps what we thought would be a good idea. So that was the basis for this. It was really sort of budget-based at the beginning, and TQS was a great framework for getting us down the road to really become more efficient and more effective at what we do.
And what about the problem Public Defender Jensen was having?
They changed that whole system over so that now they made a key just for us, but we don't have to wait, you know, for people to come back from their break. It's a time saver and it's an incredible aggravation saver.
One small problem solved, but it's not all that easy. There is court staff to consider.
So what's different about TQS? Why do we even need to spend this time? And I know that was my initial reaction.
I think it's incumbent upon leadership to always answer that why question, what's the purpose and rationale? And what people want to know in any organization, not just courts, if we go through all this work, did it make a difference?
Management has to be in it all the way. You can't just appoint people to go do this. You have to do it yourself. You have to be totally involved in the quality project. And if you're not, people are just not going to buy in.
It really brought a lot of us up short that, whoops, this is total quality service, not just partial quality service.
You have to spend a lot of time with the people, trying to convince them that quality is a good idea and that this effort is going to help them in the long run, that they'll be making themselves a better place to work.
As we got down into the different layers and realized that everybody that we come in contact with, they're our customers, and they should be treated with the same respect that we treat our judges.
Putting in place a total quality program is done in stages, and the heart of the program is measurement.
Are we doing anything differently, doing anything better than we would have had we not spent all this time? So the most motivational thing in the world is evidence that what we did worked.
The evidence comes from using data and statistical sampling to find out whether you're doing a good job.
The trick is to find what it is you want to sample. One of the things that we've looked at is timeliness, and we have managed now to get, in March, over 90% of the documents that came through the office were docketed within 24 hours. There was a time when we thought that was impossible, but we can do it. It requires that you put some effort, some time, some staff energy into gathering numbers and analyzing them.
Most everything's getting opened. At least 87% of everything that comes in as a case opening is opened within the first 24 hours. The reports are not in and of themselves our total quality service program. We use the reports to enable us to gauge our progress and to provide feedback.
I think it helps just that, you know, we communicated with each other on ways that we can help each other out.
The biggest benefits that I have seen are an increase in the morale and the trust here in the court.
I take it to heart and use it. It gives me a good feedback on what I'm doing during the month and how productive I am. If I'm letting the team down in some way, or if I'm not doing my own share of work.
That kind of enthusiasm requires that managers stay closely involved.
I got some information.
You cannot communicate too much during times of change. During times of change, you probably should triple it or quadruple it, because the misinformation, the rumors can be just rampant. You spend all of your energy taking care of things that aren't true and not putting your energy into things that really need to be done.
Training is one of those things, says Shoemaker.
You find, once you start looking at how you do things, that perhaps there are areas where you need to do things better.
One of the things that we have shown, at least through the case manager reports, is productivity.
When we come back, we'll hear more about why the 10th Circuit's Court of Appeals emphasizes training.
Part of the change in emphasis here is going from what was described yesterday as more of a clerical workforce to a thinking workforce.
Still ahead on Court to Court, we'll see one court make communication part of its future, learn about Java and PDF, and discover more about total quality management. But first, watch this.
I'm an evaluation form. You've surely seen me before. Well, I'm part of your materials and I perform a vital chore. Well, the information in me helps the center to take stock. It helps them make their programs work to help you do your job. Please fill me in. Please fill me in. Oh, we need this information. Please fill me in. Please fill me in. Oh, we need to know the score. Please fill me in. Please fill me in. Your feedback is important. And if you don't complete this form, we'll sing this song again.
Your feedback is important. Please fill in the evaluation form available in your program materials or online on the JNet. Ready to take the next step? The Federal Court Leadership Program is now taking applications for its next term. Learn new leadership skills, enhance your problem-solving and decision-making abilities, understand how to motivate and inspire others, and get a better sense of your role in the wider court family. The 2.5-year program combines face-to-face workshops, online computer instruction, independent study, and temporary duty assignments, all designed to build key skills and encourage participants to lead from where they are. Enrollment is limited to 75 and is open to all current supervisors, managers, specialists, and court unit personnel, except probation and pretrial units, which have their own leadership and development programs. You can get more information and download an application form from the Federal Judicial Center's homepage at jnet.fjc.gov. Click on Education Programs or contact Fran Toller at 202-502-4128. The next step is yours.
As we've seen so far at the Court of Appeals for the 10th Circuit, a quality service program is one way to create a more productive future. Through its survey of customers, the court found that layers of management impeded an efficient workforce. So the clerk's office and staff changed how they worked. As we'll see in the rest of our story, That wasn't easy. Two important ways to deal with changes are communication and training.
People really want to do a good job. If people aren't doing a good job, you have a management problem. It means that they need training. There are some few people who don't care to do a good job, and those are the ones you need to get rid of. But by and large, everybody wants to do a good job.
And also, the teams use this information to distribute work more equitably. That's probably going to be a little difficult for the print shop team because...
The 10th Circuit Appellate Clerk's Office identifies training needs two ways. First, by asking the staff what training they want.
And the second thing is using the Standards Committee, which is made up of 5 case managers who look at case files and look at how we docket and identify areas of weakness which may require unit-wide training.
People or teams can check themselves rather than having the committee sit here and go through with a green marker during the periods and commas, checking up after somebody.
People in the office started looking at us as basically police, and they didn't like it at first, but we've evolved now to a point where everybody is very good about watching what they do.
A more streamlined court also meant removing several layers of management. This was not easy to accomplish.
You're going to get some resistance from lots of folks because we all get very comfortable with doing the things we've always done.
For 25 years, the deal has been that if you show up for work every day, you will be promoted, period. We've changed that. Our hiring has changed. Our focus has changed. We want thinkers. We want doers. We want people who are going to grab that discretion and run with it.
Self-directed teams have been part of implementing total quality in the 10th Circuit's Court of Appeals.
Our teams, because they have lots of discretion, make a lot of decisions that were formerly supervisory type decisions.
It was a change for all of us because we were more or less supervisors of our team.
The positive things about those changes are that employees are more autonomous, they're more empowered, they feel, I think, as a whole, much more able to be in control of their own workflow.
He asked me if I wanted him to put some of that in the motion, and I said, if you'd like a ruling by Friday, put it in the motion.
The negative is that change is hard for people.
At one time, we're considered team leaders. Then we became like team coordinators. Basically, we were just to make sure that the work got done, but we were now more on an even level with all of our teammates.
And incorporating those changes had some effect on people in their communications with each other.
Audrey Weigel's team was typical.
They had to get used to the idea that, oh, I'm now ultimately responsible for exactly what it is that I'm doing. And sometimes that maybe took a little bit of time because it was easier for them to look at their team leader and ask the question, what do I do, how do I do, instead of maybe figuring out for themselves.
It did not affect our salaries. The thing that affected me the most, I think, and I learned to accept it, was the loss of prestige. I was no longer the leader. I was one of the group.
We've had conflict between court staff. We've had some conflict management to staff because empowering employees and giving them control and discretion means they're going to use it. And sometimes you get disagreements because of that.
What is the appellate court's mechanism for dealing with these issues?
We talk a lot now, and sometimes it's talk that has some conflict in it, but there's a lot of talk and a lot of communication.
It worked out fine in the long run because I was no longer perceived as the boss. And so the other team members were more at ease with me.
And I think that TQS has brought a softer and almost a freer approach to our work. And in the long run, it's made it a little more fun.
While fun may not be the goal, it's a nice byproduct. A total quality program is just one way courts can respond to trends they see on the horizon.
Without the trends, we probably keep doing the same thing the way we've always done it. And the trends are kind of just like little red flags saying, have you thought about this? Have you thought about this? Does this change anything in how you do business?
And I think it's important for other courts to know that they can use this framework within their unique court culture, that it is not a rigid program, it is something that is flexible enough to accommodate the differences within courts.
TQS isn't something a court puts in place and then forgets about.
It's a continuous program of constantly looking for ways to improve. And if you do that, then you just keep doing that. You never stop.
We often find ourselves perplexed by terms that seem to swirl out of computers and the digital world. Here with more words to know is my colleague, Bob Fagan.
Hi, and welcome to Words to Know. It used to be that a great cup of Java was all some folks needed to get started in the morning. But today the word Java has a whole new meaning because of computers. Take a look at this setup. You'll hear the word platform a lot in discussions about computers. It doesn't mean the shelf the equipment is setting on, but rather the computer's hardware and operating system, the instructions the machine understands to carry out its tasks. Computer programs run on operating systems, and programs are written in a computer language. So what is Java? Java is a general-purpose programming language whose strength is that it allows a single piece of software to run on any major operating system. Java's heart and soul is captured in the phrase, write once and run anywhere. Java is understood by PCs, Macs, and mainframes, as well as the new NC computers. I'd call that instant compatibility. But there's more. Java also gives its users interactive and multimedia capabilities. This makes it well suited for use on the World Wide Web. Java computer language creates content that changes in response to user actions. Think of it as dynamic data. This makes information more accessible and easier to digest. Java's flexibility has led to development of such things as a wearable computer. Believe it or not, it's a Java ring. And yes, it actually contains a computer. In years to come, Java will mean more and more user-friendly applications, not only in our computers, but also built into the next generation of phones, TVs, smart cards, and even our home appliances. Why Java? Well, its creators named it for the coffee shop they often went to. But we've come a long way from a neighborhood coffee shop to a very useful programming language. Speaking of useful, what about PDF? Have you ever electronically sent a document to someone and then found out that what you sent was no longer a usable document? The page numbering system was lost. The form that you sent looked like a jumble of programming symbols. Well, PDF is a computer file format which captures formatting information and makes it possible to send documents and have them appear on a user's monitor and be printed as they were intended. By the way, it stands for Portable Document Format. PDF is used by court staff primarily to publish court rules, orders, and other documents. Attorneys use PDF to convert their legal documents into a format that, when sent electronically, can be read by any user, regardless of the type of word processing software the user has. Using Adobe Acrobat products, folks in the court can create a document in their computers or scan an existing document and save it in PDF. The person to whom the document is sent must have Adobe Acrobat Reader, which is software that can be downloaded free from the internet. When the document is transmitted to users, they see it on the screen as if they were holding it in their hands. In the same way, lawyers can convert documents in their own offices into PDF and know that the forms electronically filed with the court are as they want them to appear. Think about that a second. Better service to court customers that comes with easy access to documents on the computer and maintaining the integrity of the document. Another great thing about PDF is that you can work with documents without even touching a piece of paper. In fact, Yvonne Evans, clerk of the U.S. Bankruptcy Court for the Northern District of Georgia, one of a number of courts leading the way in electronic implementation, refers to PDF as paper cuts disappear forever. Now there's something that's almost as wonderful as a good cup of Java. That's it for this edition of Words to Know. If you have any suggestions for words you would like discussed, please let us know. See you next time.
Thanks, Bob. You know, the FJC also uses PDF files for the court's convenience. These include products on the JNet, such as our catalog of publications, participant materials for some of our teletraining series, information about the 2 leadership programs, and supervising in the courts. The Western District of Texas Bankruptcy Court first became involved with strategic planning after attending FJC seminars about the concept and its process. The court recently sponsored a bench bar conference that was a direct result of its own strategic planning.
The United States Bankruptcy Court in the Western District of Texas in San Antonio is surrounded by history and symbols. But this court isn't resting on its traditions.
Strategic planning means for us that we have a process in which we try to control our future. Strategic planning is not a development of a vision, but it is a process to get to that vision.
We sometimes say the courts go 20 minutes into the future with their expectations, because what they do is they basically design to current budget, or they design to current capability. Strategic planning is not about solving current problems. It's not about anticipating the future. It's really about creating it.
Chief Judge Larry Kelly explains what future the court wants.
And now that we've had all these meetings, we've been bringing employees in, we've talked about the philosophy. Our key is to be a user-friendly, efficient, and effective court.
Lefevre says judges must be stakeholders from the outset. If they're not, strategic planning becomes merely an administrative process.
You need to have ownership. It needs to be early. It needs to be about policy. It does not need to be about the operational issues.
Means all the judges have to commit, period. And if they're not going to commit, then you just don't do it. You know, just work on something else. Because you're going to gore, as we say down in Texas, you're going to gore your own ox.
What strategic planning does is it forces us to think about why it is that we're doing whatever we're doing when we do it. And it may very well be that something that we've been doing for a while is actually a waste of time now. And maybe we need to rethink it.
One of the futures envisioned by the Bankruptcy Court is more education for the public and communication with the bar. In September, the court held its first ever bench bar conference organized by the court.
If we're going to be user-friendly, we need to know 2 things. Where are the problems they're facing? What are the things they would like to see? Because we can't address them if we're not informed.
A highlight of the conference was the judges' panel, in which they answered written questions from the participants.
Will there be an effort in the Western District to have a uniform system throughout the district?
As soon as they get reasonable, there will be.
As soon as everybody changes to our system, we'll be uniform.
Well, and therein lies the question.
And to have all 4 of them talking about the same issues and the same questions is just fantastic.
Attorney Michael Parker handles only bankruptcy cases for his firm.
What I envisioned happening, and what has happened in large measure, is the judges are trying to establish some uniformity of practice.
And I think the practice amongst the 4 of us, for the most part, is we don't have any problem with that. Debtors' lawyers should get paid for having to respond to a motion for relief from stay.
Well, I don't think they want to pay $600 or $800 for a lift stay to the creditor. I think that was the original question, and I think I agree with them in most common circumstances.
Communication is the key. They talk to each other, they hear it's an issue, they look at each other and say, okay, we'll do this. And that's incredibly valuable to practitioners.
And the question here is, why penalize professionals for something that the professional gets routinely from private clients, portal-to-portal billing? What think you, colleagues?
Generally what they do is they tell us that they're working on the way there and sleeping on the way home. So, you know, it's part of it's compensable.
I was fascinated to hear people, judges in particular, be willing to stand down and say, is there a way to do it better without impugning our judicial integrity, and willing to talk about doing it better.
Well, actually,
let's vote.
That's fine by me.
Okay, we'll pay you for travel.
Okay, done. See, that was easy.
This is a little too user-friendly, it appears to me.
Well, it doesn't mean it's not a fact issue as to reasonable.
Once the clerk's office and the judges are listening, which they seem to be, it makes my practice much easier. I would like to see this done again.
Are we talking about allowing, and this may be what Judge Kelly's saying, it's still a fact question, are you allowed to bill for travel if you're in fact working while you're traveling, or simply for traveling from portal to portal, you can charge a time whether you're reading the in-flight magazine or you're preparing for your hearing?
I'm willing to pay you for the time you spent traveling, period.
Okay.
And when you sit up there and say, just ask me what you want to ask me, you are showing that you're accessible. You're not hiding behind the door.
I think we've got varying practices, unfortunately, amongst the judges. Frank, you want to start with that?
We've tried, in Austin, we've tried to use...
The judges are talking to each other, and they may not have a formal ruling, but you've heard what the consensus is on an item. It becomes easier to provide certainty in the system. Once you have a larger degree of certainty in the system, you actually have a greater likelihood of settlement.
The Bankruptcy Court also involves court staff in strategic planning. Jana Breisel is courtroom deputy for Judge Ronald King.
I was skeptical because I wasn't really sure about strategic planning. I thought, oh, what's going on now?
Clerk of the Courts, Larry Bick, says that the court's goal to be efficient means that strategic planning affects employees with every task.
We ask them to evaluate why they're doing that process. Is it necessary? Can it be changed? Can we eliminate it altogether? But we also encourage them to make suggestions, and we empower them to make changes if they need to.
I gave up my skepticism when I could see that things were actually being implemented. I think one of the biggest benefits for the court has been that our employees feel like they have a voice in different matters.
Our caseload has doubled since '94, and our staffing has gone down 10%. And we are absolutely current. So the efficiency of it has been tremendous.
I commend the judges for all the efforts they put into it and their enthusiasm. If you watched them, they weren't just here as placeholders. They were enthusiastic participants in the process.
If the bar wants to make this an issue, if it's important to you, if you want to get together as a group and kind of try to get a consensus, which helps us. I mean, we're here working on this issue procedurally for you.
I think it's important for other courts to know that this is not just psychobabble. Okay, that's the people won't say that, but that's what they're thinking. They go, oh, this is just a bunch of psychobabble. That's not true. That's not true at all.
As we've learned from the judges and staff we've met today, creating and achieving a vision for a court takes commitment, hard work, and patience. Throughout the country, numerous court units are working on issues of quality, team-based management, strategic planning, and customer service, all of them striving to improve court administration now and in the future. We want to hear your comments about today's program. Here's the JNet address to reach us. Click on Court to Court and then select Online Evaluation. There's a section where you can also tell us what topics you'd like to see on future editions of Court to Court. You can send the evaluation online or fill one out at your site and mail or fax it to us. Our fax number is 202-502-4088. Thank you for watching today. On behalf of everyone here at the Federal Judicial Center, I'm Michael Burney. We'll see you in the new century for the next Court to Court.